Thanks, Chairman. Just if I could start with what Deputy Keller asked. I suppose you inquired about the adversarial system. It is an adversarial system, and it would take a mindset to change that. There are pros and cons of it. The people like Breed can have their cases advocated in a strong sense, and some of the patients feel that getting their speak out there publicly and having people publicly accountable for what has happened to them in the court setting has a positive effect in trying to balance the scales, as it were. It comes with it at a cost, and I think that the principal focus on the cost that we've been considering here is the late occurrence of the settlement and how can we bring that forward. And the fact that it's not brought forward means that there's a huge human cost to people like Breed and our parents. There's a huge financial cost, and I think that there is a problem, and people in the defence side will tell you that they have difficulty in accessing hospital records themselves. The doctor themselves have difficulties accessing records. The doctor wants his position vindicated and so on. But I think that the defend and deny policy has overridden all of this. And I just see day in, day out, and you see it, Mr. O'Quailon, Deputy O'Quailon said it, that he sees it on the 601 News, people coming out of the forecourts saying, my daughter was born 10 years ago, 5 years ago, and we just miraculously settled it 2 hours ago. I mean, what were they doing for the past 15 years? And what light shone on them that illuminated them in the forecourts that couldn't have been shone into the risk management department of the hospital so many years previously? So I think that the key to this is to obligate the medical people to tell what happened. And in fairness to the Medical Council, they have brought in that as a professional guideline, but we don't have it in the legal arena. And you do have situations where the doctor may want to admit liability, and a risk management department of a hospital may say, no, you can't, because it might prejudice our defence. I mean, I just think that that's nonsensical, because if there is a liability issue, it will come out, and why not bring it out at the outset? In relation to the statute of limitations point that Deputy O'Quailon raised, the statute was reduced at the behest of the MPS and the SCA some years ago from 3 years to 2 years, and people like Breed don't come running to their solicitors the day after the adverse event. They try and cope with the consequences of the event, and it may be a year or two before they get there. They then have to investigate the situation. And you talk to the NPS and the SCA, and they complain about cases coming late in the day. But they're meritorious cases coming late in the day, and it seems to me to be opportunistic to try and deny those people justice if they are meritorious cases. On the other hand, if there is a legitimate defence to be put up on the basis that the staff nurse in the hospital has died or some other prejudice can be shown, fair enough. Maybe there may be some argument for prohibiting such cases. But just the mere passage of time without there being any prejudice seems to me to be seems to be an opportunistic attempt to exclude people from justice. And then, insofar as Deputy Healy has mentioned, it is an unequal struggle, and there needs to be a recalibration of the scales, as I said already, and that can happen by an admission by the doctors as what happened. And there has been studies on this, and you asked about the experience in other countries. There's a man called Dr. Tim MacDonald who came in and addressed Michael's organisation a year or so ago, who has introduced the duty of candour into the University of Illinois under penalty that if a doctor doesn't admit that he has had an adverse event, he might get 6 months' salary taken off him. If he is in the progression from junior doctor to senior doctor, he may be held back. And that has resulted in the first thing, the number of adverse incidents being reported multiplying. So they went from, say, 100 to 1,000 per annum or whatever it was. But the number of claims dropped because the patients were dealt with fairly and honestly. And those that went on to litigation were easier to deal with. And they settled easier. And his statistics are startling in that event. And I mean, there is evidence throughout the world to show that defendant and I is costly. You've had it here, and and the other process does work. I hope that answers your questions.
Mr. Boylan.